Hi, I'm Dan Chambers of Chambers Law Firm, and thank you for visiting the website, and I hope you're enjoying this series that I put together on the anatomy of a criminal case. This is part 5, and I want to focus on requesting additional discovery or evidence from the prosecutor. Now, I'm going to take a step back just for a moment. In episode 4, we talked about the importance of getting the initial evidence, the initial discovery, and breaking that down quickly so that we know what the basic facts are in your case and some of the potential issues. I forgot to mention in that episode, and I want to mention it here now, that as the client, you are entitled to a copy of your discovery. Now, there may be some limitations on what can be provided to you. Sometimes the courts issue what are called protective orders that put restrictions on what we can share with you as your attorney. But for the most part, you're entitled to the discovery as well. So make sure that whether you're working with my firm or another one, that you get your discovery. Now again, there's certain things that may need to be what we call redacted, blacked out, things that you're not entitled to see by law. But make sure you ask for it. And here's why. I want you to be educated about your case. You never want to be surprised in court. Listen, as the trial attorney, I hate surprises. You as the client, with the stress that that's already going on in your life because of the case, you don't want any surprises in court. It's important for you to review the discovery so that you know what the evidence is against you. So you're not hearing it for the first time in court from law enforcement. Your attorney's already provided it to you and you've discussed it with your attorney. So make sure you ask for your discovery. In this episode, I want to talk about the importance of that now next step of following up. If you watched the last episode, you know that I broke down the discovery and I said, hey, I'm missing this search warrant, I'm missing this body-worn camera, and I've got a laundry list of things I'm missing. Now what you need to do is go back and serve on the prosecutor what's called an informal request for discovery. Now in California, it's governed by Penal Code Section 1054. There's a series of statutes there that discuss how the parties, meaning the defense, prosecutor, are supposed to exchange information. We call it discovery. It's important that once you have that laundry list, you immediately serve on the prosecutor an informal request for discovery. It's a fancy way of saying, hey, here's all the follow-up items that I need from you that are missing. I've read the discovery and there's 10, 12, 20 items that are referenced that I don't have. Please provide them to me. The reason it's important is that once you serve that on the DA, they have 15 days to comply. If they don't comply within 15 days, you can go to court and ask the judge to force them to produce it. So it's the mechanism by which you start with the DA saying, I need this stuff, and if I don't get it, I'm going to have to ask the judge to order you to give it. Most DAs are very cooperative. They understand that you need it, and they'll gather it and provide it to you. Sometimes it takes longer than 15 days for that, especially in a large case like a murder or a case that involves multiple charges. It may take them a bit longer. So there's some give and take involved, and that's where professional courtesy and cooperation becomes key in terms of getting the information you need without pissing off the judge by going in every other day and saying, hey, I need the discovery. The parties try to work informally together. But it's important to get that discovery request out immediately after you've reviewed it and you've come up with that laundry list. Hit the prosecutor with that follow-up so that you can start gathering even more information for use later on in the case at what is called, in felony cases, the preliminary hearing. We'll have an episode on that down the road, and you'll understand why it's important to gather that information quickly to make use of it at the preliminary hearing. Thank you.